I swear to God, I don't do drugs, Mr. Simpson. I'm almost 50 years old. I work from 6 p.m. to 6 a.m. every day. When I'm not asleep, I'm a full-time out there. If I had known that, I would have never took it. Very big mistake, definitely.
Well, then obviously regardless of the reason, she's taking medication that she should be taking.
I would
She
never
would not
do
do
it
that.
again a day in life.
It comes back positive as opiates. I mean,
I had no idea.
She will not do that again.
Never in life, I promise you, as God is my witness.
not good enough.
Your Honor, would
She's
it
not
be okay
supposed to be taking
if she drug tested today for you?
I'll do it every day for you.
And I do believe she tested yesterday and it was
And
negative.
Friday, every day I'll go for you. Every single day, I promise. To show you that I don't do.
counsel approach.
I can't, if it gives me a minute, I don't have no. It's just me and my baby. My brother lives away in Flint.
Senior Assistant Public Defender, working on behalf of Ms. Murdoch. Would you please state your name, ma'am?
Nicole Murdoch. Sorry, Your Honor, I didn't know I was supposed to be here. I would have been here a long time ago.
I do have a plea form, but we have a progress report. Have you seen it?
Yes, Your Honor, I'm
Go
prepared
ahead.
to address it. Your Honor, in terms of the progress report, as you can see, if you would like, I will focus in on the mist as well as the opiate, just
That's
so that
fine.
you'll have the whole picture. When Ms. Murdoch was released from the jail, she immediately went over to community corrections. She did not know that she would need $12 for her testing, and she did not have that with her. So she came back the very next day and tested, and you'll see those two. There's the missed day.
Oh, sorry.
And then the negative.
You'll see there's the missed day, and then the day she came back. And then she stated that there was one other day that is missed, where she was unable to make a payment. Ms. Murdoch indicates, and she is also on,
I think it's where you blow twice
on the
a day.
sober league, where
Yes.
she blows twice a day. She is indicating that she was very surprised when she learned of the positive for opioids. She states that she had been at work and had been in having some
Menstrual cramps. I'm actually on the verge of getting a hysterectomy because of them.
And because of that, she had gotten some pain medicine from a colleague. She did not know that it was an opiate. She had no idea. She is willing to test today, and she indicates that she does not use marijuana. She has not had any positive sober link, and she is willing to test twice a week if that would make Your Honor feel more comfortable with her out in the community. But she is very adamant that she was not aware that she was given anything that was an opiate or that would test like an opiate.
I swear to God, I don't do drugs, Mr. Simpson. I'm almost 50 years old. I work from 6 p.m. to 6 a.m. every day. When I'm not asleep, I'm a full-time out there. If I had known that, I would have never took it. Very big mistake, definitely.
Well, then obviously regardless of the reason, she's taking medication that she should be taking.
I would
She
never
would not
do
do
it
that.
again a day in life.
It comes back positive as opiates. I mean,
I had no idea.
She will not do that again.
Never in life, I promise you, as God is my witness.
not good enough.
Your Honor, would
She's
it
not
be okay
supposed to be taking Go ahead.
if she drug tested today for you?
I'll do it every day for you.
And I do believe she tested yesterday and it was
And
negative.
Friday, every day I'll go for you. Every single day, I promise. To show you that I don't do.
Counsel approach.
I can't, if it gives me a minute, I don't have no. It's just me and my baby. My brother lives away in Flint. Enter myself in for how long? Sure, I'll have to get, yes, I'll come back to.
Your Honor, I would just like to state again that she is very apologetic, that she she knows that she should not have taken medication, and she did not realize that it was an opiate.
I did not.
She just thought it was regular medication.
Your Honor, I
If Your Honor
promise.
is going to incarcerate her, we would ask that she have the opportunity to make arrangements for her son. She has a brother who lives in Flint that she can get in touch with and hopefully get her son there tonight, and she will report to the Washington County Jail by 8 a.m. tomorrow morning.
I came as soon as you asked me today.
And she is willing to testify.
For sure.
I'll adjourn her probable cause conference to the 12th, March 12th at 9 a.m. I'll give her a chance to get arrangements to take care of her child. So I'll indicate that I'll continue her bond at this point in time. Defendant is to report to the Washington County Jail with ID at 8 a.m. tomorrow morning. Understood?
Yes, sir.
At which point then her bond will be revoked.
Sir, do you know how long I should advise my brother or my son?
At least a week.
Okay. Thank you. I'm sorry, Your Honor. I do apologize for anything.
Thank you.
Court calls the case, People versus Jennifer Bishop.
Alexander, on behalf of the people, Your Honor.
Jordan, please state your name for the court.
Ethan Jordan.
All right. I have before me a plea form indicates that he would be pleading guilty to an added count of attempted resisting and obstructing a police officer. That's a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. Defendant is also agreeing to write a letter of apology to the victims, and also there is an agreement to sentencing under HIDA. That's the court's full understanding of the agreement.
That's correct, Your Honor.
And that is a correct statement.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Ethan Jordan.
Sir, it is this court's understanding that you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
I do.
Still wish to, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court. You understand that?
Understood.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I have.
Any question regarding those rights?
Sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights. If you are part of a trial, you understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Understood.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am.
Were you on probation or parole at the time of this offense?
I was.
Both? Well, not
Probation.
both. You were on probation? Out of what court?
15th district.
You understand that your entry of a plea in this case could be a violation of that probation.
I do.
You understand that as such, that court could sentence you to the maximum allowable under that other charge.
I do.
And understanding that, you still wish to plead guilty to this charge.
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily?
I am.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
November 29, 2025, at the location of 1201 South Main Street, City of Ann Arbor, Washington County, State of Michigan. Did you come into contact with a police officer from the University of Michigan Department of Public Safety?
Yes, sir.
And what happened?
I was denied entry into the stadium based off an invalid ticket, and
You were denied entry into the stadium without a ticket.
an invalid ticket, but yes. I resisted a not campus security, stadium security officer. And then after which police officers came to assist in removing me from the stadium. And it was at that point where
So you went to the stadium and you just decided to go without a ticket?
I was kind of like scammed out of a ticket.
You were scammed out of the
I
ticket?
purchased a ticket that was invalid.
Oh,
So
you're still gonna go anyway.
no, that wasn't the intent to.
Mr. Jordan, you were denied entry into the stadium, correct? And security tried to get you to leave
Correct.
and escort you out,
Correct.
and you resisted that attempt.
Correct.
And then U of M police officers, uniformed, approached, and they attempted to assist the security and
Yes.
escort you out, and
Yeah.
you continued to resist.
Yes.
And you realized they were giving you lawful commands to leave the stadium.
Eventually, I did. Yes.
Did you realize?
Well, no, you eventually left, but you realized that at the time they were giving you the order or attempting to try to get you to leave the stadium, that they were giving you a lawful command to leave the stadium.
Yes.
You understand that between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I do.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
We're satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 50th District Court probation. Sentencing in this matter will be
March 31st at 9 a.m.
March 31st, 2026, 9 a.m. before Judge Garwood. Bond will continue.
Very good.
Thank you.
Thank you very much, Your Honor. Have a good day.
Thank you.
All right. Record should reflect we had a bench conference in this case. Really, there's a motion by the people to modify his bond.
And that's correct, Your Honor. It's our understanding that this case was picked up while the defendant was on bond for another case involving controlled substance delivery and manufacturing as well as probation in circuit court. And I believe per the statute, he should have been given an surety bond. So this time I would be re-requesting our original request of $50,000 cash surety. However, I understand the court. Thank you.
And Your Honor, we do understand the people's concern as well as what the statute states. However, my client has been out on bond on this case with absolutely no issues. We know that there is another case. He was present for his preliminary examination on Tuesday for that matter. I believe that the issue of bond was addressed at that time and the judge put him on a home confinement tether GPS. That was Tuesday. He does have that tether on to my understanding. Yes, there may be a violation. It has yet to come up in circuit court as of now. However, he's been doing everything he's supposed to do on bond, Your Honor. So I'm asking that the court, if there is a requirement to put some type of cash component, make it as minimal as possible to allow my client to continue complying as he's been doing.
All right. I would find that the setting of a personal recognizance bond under the circumstances was use of discretion by the magistrate. Setting bond. I am going to take into account the fact that, yes, it should be some type of surety bond, but I'm taking into account that, as defense has indicated, he's been doing what he's supposed to be doing, other than picking up this case while he was on bond on the other thing. But since that point, he's been cooperative. He's been doing everything. So I'm not going to require what the people had requested, and not necessarily a surety bond, but I'd be looking at it this way. I'm going to set his bond at a 10% bond in this matter, at least that way he can post it. I will also set the, you want this set for preliminary,
Yes, Your Honor, please.
and your discovery is complete.
To our knowledge, Judge.
All right, discovery being complete. Would the people have their witnesses available the 17th?
Double check on the. We are just waiting on the final call.
Pardon?
Requested the 911 call, but I have not received it yet.
Okay. So
We're
you're-
fine
You're
proceeding.
willing to proceed?
That's right,
with
Your
the
Honor.
911 call. All right. preliminary examination in person, March 17th, 2026. 9 a.m. before Judge Moore. All right. I'll set his bond. Defendant is remanded.
Thank you, Judge.
Thank you. Versus Theophilus Smith, 2 cases.
They're representing Mr. Smith.
Theophilus Smith.
Thank you. What are we doing?
Your Honor, we are continuing negotiations in terms of hopefully coming to a resolution very quickly. We are asking for a 1-week adjournment. Perhaps we should approach, if we could, please.
You want 1 week?
Yes, if so, I am standing in for Mr. Bellinger, and Mr. Bellinger and Mr. Childs have been in ongoing conversations, and my understanding is that they may be close to a resolution that possibly could have been handled had Mr. Bellinger been here today.
March 12th, 2026, 9 a.m. Bond continue.
And may I please speak on bond?
Go ahead.
Mr. Smith is requesting that the court allow him to be released to his mother's home in Canton. He indicates that he will continue to receive community mental health services, that he will return for all future court dates.
I'm not going to change his bond at this point. He's a week out. Let's see if there's a resolution on it. And if there's a whole thing put together and I have more information about where he would be, then I may not have a problem releasing him at that point. But I'm not going to change anything now.
All right.
All right.
All right. Thank you.
Thank you. Okay. Does call the case of People versus Olin Thurman.
And on behalf of the people, Your Honor.
Public defender with and on behalf of Mr. Thurman. Would you state your name?
Olin Thurman.
Thank you. What are we doing
Your Honor, we are requesting a preliminary examination
on both cases?
That is correct, Your Honor.
Discovery is complete.
That is my understanding.
People have their witnesses available the 17th. Preliminary examination in person, March 17th, 2026, 9 a.m. before Judge Moore.
Your Honor, if I could address bond.
Yes.
The defendant has made 2 complete calls to the victim since being arraigned. I have one on 2/27 at 4:12 p.m., which I believe would be after he was arraigned, and one on 2/28. He also has 8 attempts to contact her number that were not answered as recently as March 3rd. So at this point, I'm going to be asking that phone and text privileges be revoked.
Any response?
At this time, Your Honor, we have no response.
Defendant's phone and text privileges are hereby revoked. Texting privileges are hereby revoked.
This courtroom sequence shows multiple important legal moments involving bond violations, plea deals, probation risks, and judicial discretion. The most emotional moment came when Nicole Murdoch admitted taking unknown medication that later tested positive for opioids. Even though she claimed she did not knowingly use drugs, the judge focused on personal responsibility. In probation or bond conditions, courts usually apply strict compliance standards, meaning intent often matters less than the actual violation. That's why Judge Simpson said, "Not good enough," despite her emotional explanation. The judge still showed balanced discretion by allowing her one night to arrange care for her child before reporting to jail. Instead of immediate custody, her bond was continued temporarily and then revoked the next morning. This demonstrates how judges often weigh public safety, accountability, and family hardship together. Another key legal moment involved Ethan Jordan's guilty plea to attempted resisting and obstructing police. Before accepting the plea, the judge carefully confirmed that Jordan understood all constitutional rights he was giving up, including the right to trial and appeal. The judge also warned that because Jordan was already on probation, This new plea could trigger additional punishment in another court. This is a standard but critical plea procedure designed to ensure the defendant knowingly and voluntarily accepts responsibility. The final bond hearings highlighted how prior criminal history strongly affects pretrial release decisions. One defendant received a reduced bond because he had been cooperating despite new charges, while another lost phone privileges after allegedly contacting the victim from jail. That decision shows how courts aggressively enforce no-contact orders to protect victims and prevent witness intimidation. Overall, the hearing demonstrated how judges balance compassion with strict enforcement of court rules and public safety concerns.